Hi, I'm Eric Johnson of Utah Family Law TV, and this video is in response to the comments and questions we got about our previous video answering the question, at what age do children get to choose with which parent they're going to live? Now, if you saw that video, briefly I'll tell you the answer is never. Minor children don't have the right to choose with which parent they're going to live under the law. There are these people that will tell you, oh no, that's not true. After the age of 14, children get to choose. That's not true. And I think I know why there's so much confusion about this. By the way, if you find anybody, a lawyer or otherwise, who tells you that the law allows that, just ask that person to show you the law or the case. They won't be able to find it. This is where I think the confusion may come up. There is a code section in the Utah Code. It's section 30-3-101E. And what that says is that the judge, during a child custody and parent time dispute, can, if the judge wants, interview the children to ask what their preferences might be as to which parent they live with. But remember, first of all, the judge isn't required to do that. You have to ask the judge, and the judge has to agree. And then even if the judge does interview the children, the judge is not bound by whatever preference the children may express. So the children might say, I want to live with mom, or I want to live with dad, and even though the judge knows that, the judge may choose otherwise for various reasons, or the judge may not believe the kids or think they're being coached. So at no time do minor children get to choose where they live. They can, if the judge will allow it, speak to the judge and tell them what their preferences are, but the judge isn't bound by it. So why would I tell you about this? First of all, I have never had a judge agree to interview the children in my 20 years of practicing law. They just don't like to do it. That is changing, and I think that some judges are starting to come around understanding, well, if the code says I can do it, I'm certainly qualified to do it if the legislature says so. And some judges are starting to see that custody evaluations, which is what we traditionally have used to find out what the kids' experiences and preferences are, these custody evaluations are way too expensive. They cost thousands, and when I say thousands, I don't mean $2,000, I mean $5,000, $6,000, $7,000, $8,000, and they can take 4 months, and they typically take longer. Some lawyers, such as myself, and some judges are saying, if the kids are old enough where we don't need to have a child psychologist meet with them in a room with fuzzy animals and stuff like that, we can just simply talk to a child and have a mature conversation. Some judges are now starting to warm up to the idea of meeting with the kids. It's fast, it's free, and they get to hear the opinions and the experiences of the children directly. But remember, kids don't get to choose. So if you're a non-custodial parent and your child says, I'm 15 and I want to live with you now, that may be useful, but you can't just tell your ex-wife or ex-husband, he's staying with me now, or she's decided not to come back. You will be held in contempt of court, and you could even be arrested for custodial interference. So you've got to go to court to get that fixed, and you've got to have the court either speak to the children or have a custody evaluator speak to the kids to find out what their preferences are. This is Utah Family Law TV. Thanks for watching.